Bismillahirrahmanirrahim. So, my team member will present about immunities and diplomatic protection. We prepared for Professor Dr. Ratnanya Wahid. So, this is my team member, which consists of one Nurul Kolbi binti Wan Omran, Muhammad Haris Hiskandar bin Fakrazi, Juris Nur Hafiza Aini binti Ishaq, and also me, Nur Syahidah Atika binti Muhammad Shaufi. So what is actually immunity? So immunity is actually a doctrine of international law that allows an accused to avoid prosecution for the criminal offence. Let's discuss more detail about this. So, actually, immunity is a principle of international customary law, and there are two conventions that regulate state immunity. The first one is the European on State Immunity 1972, adopted by Council of Europe, and the second one is UN Conventional Jurisdictional Immunities of State and Their Property 2004, yet into forces. In practice, what can we conclude is state immunity from jurisdiction means that a state that cannot be sued before given the consent. So, that's all from me, Nur Syahidah Atika binti Muhammad Shaufi, 261565. So the next about immunity and also the types of immunity will be discussed more detail by my friend Wan Nurul Kolbi. That's all from me. Thank you.
My name is Wan Nurul Kolbi binti Wan Umran, matric number 261302. My friend and I will talk about types of immunities. What is immunity? State immunity or sovereign immunity, as it often referred to, is a principle of international law that has become part of the national law of many states. It derived from the theory of sovereign equality of states, as a consequence of which one state has no right to judge the action of another by the standard of its national law. It protects an entity in two ways, by conferring immunity from adjudication and by conferring immunity from enforcement and execution. If a party is immune from adjudication, the court will be prevented from considering claims against the party and awarding a judgment or declaring rights and obligations against it. If a party is immune from enforcement and execution, the court will be prevented from recognizing a foreign judgment or an arbitrary award against the immune party and from making or executing orders or injunctions against it. Next, the type of immunity is immunity rational material. Immunity rational material provides that they will not perform in a private capacity. It survives the term of the official function of the representative, Article 39(2) of the 1961 Vienna Convention, specifically providing that diplomats continue to benefit from criminal immunity after the end of their accreditation regarding all acts performed in the exercise of their diplomatic function. Immunity rational material is controlled by the foreign state, not only in the sense that it can be waived by it like immunity rational personae, but also in the sense that it must be claimed by it. The link established by the court between the claim made by the state in favor of the immunity rational material of its representative and its international responsibility does not exist with the same strict necessity as far as immunity rational personae is concerned, as that immunity may relate to private acts for which no international responsibility of the state may exist. Like immunity rational personae, immunity rational material does not apply for the purpose of the ICC jurisdiction between state parties.
Next, I will continue about the type of immunities. My name is Muhammad Haris Iskandar bin Fakarazi. My metric number is 262425. The second one is a personal immunity or immunity rational personnel. This is an immunity that been granted to certain officials because of the office they hold, rather than in relation to the act they have committed. Immunity rational persona can be defined as any act of authority of another state which will hinder the higher official in the performance of his or her duties. According to Chaser, personal immunities are extended to cover personal activities of an official, including immunity from arrest and detention, immunity from criminal jurisdiction, immunity from the civil and administrative jurisdiction of the host state, and there will be no immunities hold for private immovable property unless it is held on behalf of the sending state for the purpose of the mission, issue of succession, professional or commercial activity exercised outside of the official function, or the official has voluntarily submitted to the proceeding. Personal immunities change with the cessation of the post. Diplomatic immunity is a form of legal immunity that ensures diplomats are given safe passage and are considered not susceptible to lawsuit or prosecution under the host country law, although they may still be expelled. Modern diplomatic immunity was codified as international law in the Vienna Convention on Diplomatic Relations in 1961, which has been ratified by all but a handful of nations. The purpose of diplomatic immunity was developed to allow for the maintenance of government relations, including during periods of difficulties and armed conflict. International Organization Immunity. International organizations receive the same privilege, immunities, and exemptions as a foreign government. Some of these privileges, immunities, and exemptions listed under Section 4 of the Act. One of the things that international organizations enjoy is immunity from search and confiscation of any property and asset owned, exemption from any internal revenue tax imposed, and free from baggage search and any other procedure related to the custom duties. This international organizational immunities is first been introduced by United States of America.
Employees and officers of international organizations designated under the Act also receive benefits. Even though the Act provides employees, officers, and their family members many benefits, it does not grant full diplomatic immunity. Moreover, any of the rights granted can be waived. Also, organizations and their employees can only receive these benefits if the Secretary of State notify and acknowledge the international organization and its workers.
So now, let's move on to the immunities granted according to the Vienna Convention on Diplomatic Relations 1961. As we all know, there are many types of immunities. So for this part, we will discuss those immunities in detail, especially the one that are mentioned in the Vienna Convention itself. So here is the actual front cover of the convention. It is not it is quite simple, not too many details. It was done at Vienna on 1961 before it came into force on 1964. So what is Vienna Convention on Diplomatic Relations? Okay, the first thing, it is an international treaty that defines a framework for diplomatic relations between independent countries. And within this convention, it has the privilege and immunities that enable a diplomatic agent to perform their function, their roles, their duties without any fear of coercions or harassments by the receiving state. And altogether, this convention has 53 articles. And the main purpose of this Vienna Convention is to ensure the efficient performance of the functions of diplomatic mission as representing states. And from those 53 articles, there are several that discuss in detail of those immunities that a diplomatic agents receive, but still it is too many to cover. So therefore, we will focus on a few articles, which is Article 29, which explain about the personal inviolability. So he shall not be liable to any form of arrest or detention, brings the meaning of a diplomatic agent is secure from any violation, assault, or trespass. The next article is Article 31. Article 31 is on the immunity from jurisdiction. A diplomatic agent shall enjoy immunity from the criminal jurisdiction of the receiving state, meaning a diplomatic agent cannot be tried or punished by the local criminal courts of the receiving state. But it does not mean that they are allowed to do whatever they want. They are still obligated to respect the laws of the receiving state. However, while remain bound by the laws of the sending state. And then the last article is Article 32. Article 32 is on the waiver of immunity, the immunity from jurisdiction of diplomatic agents and of persons enjoying immunity under Article 37 may be waived by the sending state. In a nutshell, this article stated how a sending state have the right to reject the immunity to be given to a diplomatic agent. So that is all from me. Thank you for listening.